I recently had a client who came to our firm after having suffered an injury in an emergency room setting. It was an interesting case because the client believed he was having a heart attack at the time, and they administered medication to deal with the nausea, and he ended up suffering injury that had nothing to do with his original complaints. Florida does have a law, which we call the Good Samaritan Law, that would require a heightened standard of care or proof to establish any claim for compensation that occurs in an emergency room setting if it is being administered because of an urgent situation. So all of these claims are dependent on the details of the facts. Our job is to understand the medicine and have a full investigation of all of the facts that have led to the injury, because you can suffer injury in an emergency room that is not covered by the Good Samaritan Law if it is not in response to an urgent situation. So regardless as to whether or not an injury is suffered in an emergency room, we will prosecute it to the full extent of the law, and if necessary, look at trying to prove the heightened standard if it is being done under the scope of the Good Samaritan Law.